Today, we are talking a bit about the Karen Read fallout, what Commissioner Cox of Boston PD had to say about Officer Dever. And Alan Jackson wrote a strongly worded letter about Officer Dever. And I have some thoughts about that too. So we really need to take a look at some of the video and run it back.
Did you have any conversation with any other party about your potential involvement in this case?
No.
Did you have a conversation with anybody in the commissioner's office at Boston Police Department?
Not about anything malicious.
I didn't use the word malicious. Why do you say malicious?
I had a conversation.
Why would you say that?
But it was my department saying, regardless of what I need to say on the stand, they support me.
You were asked to go to the commissioner's office, correct?
Yes.
Did you find it unusual would you call yourself a rookie back then?
Yes.
Did you find it unusual that a rookie police officer would be called up to the commissioner's office personally?
Like the boss.
To discuss a matter.
It was a reflection of how good of a leader he is. It was not anything that I found unusual, given the fact he is someone who wanted
It is a reflection of how good of a leader he is.
to show support for his officer.
At some point, did the commissioner say to you that Boston Police Department, insofar as your connection to this case is concerned, Boston Police Department fully supports you?
Yes.
Did he also say, do the right thing?
That's a direct quote, so I can't recollect if he said a direct quote 2 years ago.
A year ago, when you
Do you or
talked
do you
to
not?
us, the defense, did you tell the defense that when you were called up to the commissioner's office, he told you two things? Commissioner Cox told you, number one, the Boston Police Department supports you, and Officer Dever, do the right thing.
So he said my name correctly. He said Dever, and
That's my mistake. Let's see, you want me to repeat the question so I get
So,
right?
Mr. Jackson, let's go ahead and answer, please.
yes, and he said nothing with the intent of guiding me one way or the other.
He said my name correctly, and he said nothing with any intent. You don't know what his intent is.
What's matter? I asked you what he said to you. What were his words to you?
That he supports me.
And
Just wanted me to tell the truth up here.
his words were, do the right thing, right?
I don't recall.
This is her bossy boss, the top brass of Boston PD.
Your name came up during the recent Karen Read trial. You got a visit from Officer Kelly Dever. The defense implied that you influenced her testimony.
Immediate statement, I have nothing to do with that.
Do you want to respond to that?
I have nothing to do with Karen Read. Matter of fact, I didn't even know this person was associated with the Karen Read case. You know, I have an organization, Philip.
I didn't even know this person was associated with the Karen Read case. Not only was the victim Boston PD, the crime scene was the front lawn of a Boston PD officer. I have nothing to do with Karen Read. You don't? You didn't investigate it, but your department is enmeshed in it, and your department should want justice for John O'Keefe.
3,000 people, and we support all our folks. And the reality is that, you know, I get information passed on whether people are high or low, and I encourage everyone, right? And if you're going to work here and you belong here, then we're going to encourage you. I have no idea what they're talking about with Karen Read. It had nothing to do with Karen Read. No discussion about
Did you
Karen.
tell Officer Dever to do the right thing?
I didn't know she was even associated with that case. So.
I didn't know she was even associated with that case. Then why was she in your office? Because then there's no reason to talk to her.
You know, I don't know. I was struck. Like, what do I have to do with the Karen Read race? I never have said those words together. And so the fact is, you know, it's much to do about nothing. we have employees here that we have to develop and encourage and do things, and I do that for tons of our employees.
Do you feel that you were inappropriately drawn into this as some sort of boogeyman?
That case is over, and you know, we've got a lot of other stuff to talk about. I have nothing to do with Karen Read. I was in the
That case is over. I have nothing to do with Karen Read.
state of Michigan. So,
And then he says, I was in the state of Michigan. What do you even mean? Like you were on vacation? It's interesting to me that he and Dever both use the word encourage quite a lot. I do not believe that he did not see, or at least was told about Dever's testimony. I have more questions than when Dever testified now that he's saying, I didn't even know that person was associated with the Karen Read case. That doesn't even make any sense. And none of the media followed up with, so you never met with her? Because he didn't say he never met with her. The question that was asked was, the defense insinuated you influenced her testimony. And he said, I didn't even know she had anything to do with the Karen Read case. It's not a comfortable, easy answer. It's like, why are you even asking me about this? Well, because Officer Dever's testimony was fucking wild. That's why. And she said she met with you. And she said that you were encouraging her. And you said, I encourage a lot of my officers. I didn't even know she was connected to the Karen Read case. I do not find that to make any sense at all. Because there's no reason for her to be in your office and have a conversation if she's not connected to testifying in a high profile case and changing her testimony from what she told the FBI. There's no reason for her to be in your office. There is a reason for her to be in your office if she is going to get on the stand in front of everyone in your state and say, yeah, what I told the FBI wasn't true. I retracted my statement. It's been proven to me that what I said I saw couldn't be true. I created a false memory. Ma'am, how can you ever testify in a case ever again? She didn't bring up on the stand that she met with the commissioner. The defense asked those questions point blank. So somewhere the meeting with the commissioner came up, either in a statement to the FBI or in other information the defense had, because they asked her about it. She didn't bring it up. So it's memorialized in some way that the defense knew to ask a question about it. I don't think she's able to testify in any other cases. I think her testimony in this case has blown up her career. And she said, I'm here to do the right thing. That had to be a created memory. A defense attorney coming into a case is going to be like, well, how do I know you didn't create the memory when you created this police report? And I imagine a jury in Massachusetts sitting there with her testifying, isn't it true that you gave a statement to the FBI and then recanted the statement and then said it's because you created the memory, you invented a memory? How can a jury trust you? After she testified, a lot of you said, is she going to get in trouble for testifying? And I said, the trouble isn't going to come from like official action. It might, we'll see. We're going to look at that next. But she's not able to testify again. She's rendered herself unable to perform a lot of the investigative functions of a police officer, and she is young and new in her career. But she can't go do a patrol shift, because if you bring her in on a speeding ticket and the driver's like, I was going 25 in a 25, and she's like, you were going 55 in a 25. Well, did you create that memory? How did you perceive it was 55 in a 25? What did you do to memorialize it? It is going to be a problem if she ever needs to testify. And so much of what law enforcement does requires her to testify. And if you're a defense attorney and you have a case and her name is on a report, are you taking a plea deal? Or are you like, nah, run this to trial, put her on the stand? Because a jury in Massachusetts that is on a different case is allowed to be aware of the Karen Read case. And I imagine most of them would have some maybe not fond feelings. The other person who thinks that her career should see some negative impacts is attorney Alan Jackson. And this was provided to Ted Daniel. This is from July 10th from Alan Jackson's law firm to the police commissioner for Boston PD, requesting Brady Giglio disclosure for Officer Dever. Dear Commissioner Cox, pursuant to obligations established under Brady v. Maryland, And Giglio v. US, this letter serves formal notice that a member of your department, Officer Kelly Dever, must be included in the Brady database. As you are no doubt aware, Officer Dever was a witness called by the defense in the matter of Commonwealth versus Karen Read, a high-profile murder case that was tried for the second time in Norfolk County in April 2025. The case received extensive national and international media coverage. Officer Dever's involvement in the case stemmed from an interview with agents from the United States Federal Bureau of Investigation. The FBI! During which interview, Officer Dever explained to the agents in detail her observations of former Canton Police Chief Ken Burkowitz and Special Agent Brian Higgins of ATF in the Sallyport garage of Canton PD. She described seeing both individuals enter the Sallyport garage of Canton PD, where the SUV in question was located on January 29, 2022. She described in indelible detail that she witnessed Burkowitz and Higgins go into the Sallyport and stay there for a, quote, wildly long time. Not weirdly, which I have said, wildly long time. And she thought it was weird that a witness on the case, Higgins, would have access to a seminal piece of evidence, the SUV, in the investigation. Did she know at that time Higgins was a witness? How did she already know that Higgins was a witness when this happened on the 29th? During her lengthy interview with federal agents, she articulated her observations in considerable detail, including specifics about the monitors she was viewing at the dispatch desk. She described at length her observations of the two men entering the Sallyport with the SUV and claimed no issues with her memory. And she was clear with the agents that she made her observations in the afternoon or early evening of January 29th, 2022, at the end of her shift after the SUV had been, quote unquote, secured in the Sallyport. Subsequent thereto, the federal authorities provided a report of their interview with Officer Dever, both to the prosecution and the defense in the Read matter. In or about April 2025, the defense issued a subpoena for Officer Dever to testify in the murder trial, and on June 2nd, 2025, she was subsequently called and sworn to testify before the jury. During her testimony under oath, she changed her statement, claiming not that she did not make the statements to federal agents, but that her observations of Burkowitz and Higgins were a quote-unquote false memory. She maintained under oath throughout her testimony that the events she described to federal agents never happened, and that the memory she was recounting was false, and that the events she described did not actually occur. It is clear, therefore, that one of two things is true. Either Officer Dever lied about having a false memory, or she actually suffers from a condition that subjects her to false memories. In either case, her credibility and reliability as a law enforcement officer are irreparably compromised. If she lied under oath, then she is guilty of perjury. If she truly suffers from false memories, she is unfit to serve as a police officer. Her reports, statements, and testimony can no longer be presumed accurate, and in any case, current or prior involving her must be reviewed accordingly. These circumstances bear directly on her credibility and represent impeachment evidence pursuant to Brady and Giglio. I don't disagree. And I do think law enforcement and prosecutors should have to turn this over to every attorney that's on one of her cases to make sure that they know. Jackson goes on to say, given the facts, it is clear that it is incumbent on your department to immediately include Officer Dever in the Brady database, and all information surrounding her claimed false memories must be disclosed to defense in every case in which she is a witness or potential witness. As you are aware, both the prosecution and law enforcement share a constitutional obligation pursuant to the Due Process Clause of the 14th Amendment to affirmatively disclose exculpatory and impeachment information to the defense in every case. This is impeachment. If Erlinda Johnson got put on the Brady list because of the shit that went down in the Baldwin case, you gotta be fucking joking me if you don't place Dever on the Brady list. And most departments put in anything that could be impeachment in an abundance of caution, and then let each individual judge sort it out. The Supreme Court has mandated that, quote, when the reliability of a given witness may well be determinative of guilt or innocence, non-disclosure of evidence affecting the credibility falls within the Brady rule. Failure to disclose Dever's intentionally false testimony and or false memory condition would be a constitutional violation, subjecting both the prosecution and Boston PD to severe sanctions, the least of which is dismissal of every case she touches. If it is determined that your department was on notice, which this letter formally provides, and the department does nothing to include Dever on the Brady List, and thereafter provide to the defense the exculpatory impeachment materials in its possession, the sanctions can be far more extreme. Cases just would get dismissed, among other sanctions. But this would render cases even post-prosecution dismissed. If she is not in the Brady database, and if it is not disclosed, these are ifs. A, the defense can bring it up prior to trial if they are aware from all of this being in the media or a noodly Google. They can bring it up and demand that information be disclosed. If the defense does not demand the disclosure or is unaware or what have you, in a case that she is a part of, that she testifies in, goes to trial, it can be dismissed for failure to disclose this. 100%. They are in a difficult situation with her because I think she must be added to the database because the information of her testimony and the report, all of that should be turned over to every defense attorney in any case. There is the real possibility that there aren't any cases that she is a pending or potential witness on. That is a possibility. Even if there's a case where there's body cam, and even if it's a traffic stop, defense attorneys still have the right to this information because if it goes to trial, the defense still has the right to question her about this. And a jury has the right to decide. And a jury might say, look, it's on body cam and there's all this other evidence. We don't necessarily trust her, but we trust the video or we trust the other officers. That's well and good, but it has to be disclosed. She has to be able to be cross-examined about it. And it makes her a very difficult witness for any prosecutor in the future to call. It makes defense attorneys giddy. If she's not doing cases where she would ever be a witness, I think she should still be on the Brady List. It just won't ever come up. If she's doing cases where she would have to go give testimony at any level, I think that she should be on the Brady List. And I think if Boston PD wants to go a little bit of a distance in transparency to their constituents, they should tell people what they decide to do with this. We'll see what they do. I'm not optimistic on that. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.